And so this presentation tonight is intended to be at a pretty high level, meaning that it should be helpful for basically everyone listening to this, specifically those of you who are rent stabilized tenants. Um, for the lawyers who are on this call, a lot of what we go over may be things that you already know. And if that's the case, I'm sure you have a lot to teach myself. And just to give some quick disclaimers, with a lot of what we're saying, the devil is frequently in the details, right? And so there's a lot more deeper that we can go into for each topic. We're going to try to keep it pretty general just so that tenants can understand what their rights are for different topics.
And wait, James, one more thing, because some new people have joined in. Thank you all for coming in. So James is about to begin his presentation, and if you do have a question, please put it in the Q&A box, and we will answer it at the end of James's presentation. Thank you.
Thanks so much, Jakari. Do you mind going to the next slide? All right. So next slide. We'll start off here. So first of all, how do you know if you are rent stabilized? Very generally, the term rent regulation, as you might have heard, or being rent regulated, it covers two different things: rent control in the first column, as well as rent stabilization. This chart is a quick way to see the different criteria that places you in one or the other, or whether you are what is called a market rate or unregulated tenant. So some of the things that might tip you off is that you live in a building that was built before 1974. About half of New York City's available apartments are rent stabilized. And the only way to know for sure whether your unit is rent stabilized is to contact DHCR. So that's the Division of Homes and Community Renewal. It's a state agency, and they are the ones that, as we'll go through later in the presentation, basically cover many, if not most, of the things that have to do with rent stabilization. So if we go to the next slide, here is, and we'll pause here for a second. These are three different ways that you can reach out to specifically, sorry, the previous slide. The Office of Rent Administration. You can do so as a tenant by email, phone, or online. That QR code, if anyone wants to take the time to scan it right now, since it's easy to tell ourselves that we'll get to something eventually and maybe not do it. If you want to do that right now, that will lead you to that URL under online, and that is where you can submit a request to the Office of Rent Administration for the rent history for your unit. And you must include your full address and apartment number, and they will send you via mail a copy of your rent history, which will be the history that your unit, and if your unit is rent stabilized, the history for how long your unit has been rent stabilized, in addition to according to their records, the tenant for each of the years that it's been rent stabilized, and that will be your best tool in determining whether you are in fact rent stabilized. Just a quick note, DHCR's website does say that it takes approximately 20 business days for that to be mailed, which is 5 weeks or 4 weeks, if I'm doing my math correctly, and all of us lawyers like to say that we can't. That is obviously a considerable amount of time. And so I would recommend that you do that now so that you know whether you have the rights that we're going to talk about in this presentation. Next slide. So here's a quick overview of what we're going to be talking about today. We're going to be talking about required and essential services, the warranty of habitability, protection from harassment and eviction, lease renewals, succession, which is the term for when a person can succeed or continue living in the unit while it being rent regulated after a prior tenant moves out or passes away, a few miscellaneous topics, and then we're going to go into a quick discussion of who, in terms of which government agencies, can help you with what question. Next slide. So we'll start here with required and essential services, i.e. the warranty of habitability. Very quickly, the warranty of habitability is a legal principle that everyone has a legal right to living in what are sufficient conditions. And that is not just for market rate tenants, it's also rent stabilized and rent regulated tenants have just as much, if not more and different in some ways, rights to all of the things that all of us deserve, such as what are on this list: repairs and maintenance, heat and hot water, painting, janitorial services, elevator services, etc. I just want to take this second to talk about heat season, although it's been getting a little bit warmer for those of us here in the city, which has been much welcome. Heat season is between October 1st and May 31st. And during that time period, your landlord has a responsibility to keep the temperature with must be at least 68 degrees during the day from 6 to 10 p.m. If it is less than 55 degrees, and at night, it must be at least 62 degrees no matter what. So if you have an issue with that, what you should do is you should call 311 and you should basically file a complaint with them to bring to the appropriate authority, in this case, HPD, to follow up and make sure that you're getting the heat that you're entitled to. As the bottom here mentions, and this is just a little bit of a practical point for all tenants, please call 311 if you ever have any issues about your living conditions. HPD and perhaps some other agencies, which we'll talk about later, will be the ones to send down an inspector and issue violations, which are classified in terms of A, B, and C for severity, A being the least serious and C being imminently hazardous to human health. And I include the line, do not expect anything will happen if you don't, because as many of us on this call I'm sure know, you can and definitely should, of course, bring to your super's attention or your property management's attention if there are issues for them to address. But unless there's a record made that a city agency has issued these violations, it will be more difficult to hold them accountable later on and to get them to follow up, because ultimately it'll be sort of a he said, she said, your word against theirs. And so create a record and keep all your records, because you never know when you might need them. Next slide. So now quickly, we'll be talking about protection and the rights that rent stabilized tenants have from both eviction and harassment. So regarding eviction, I want to make very clear to everyone who's listening that that can only happen via housing court. And what I mean by that is that a judge issues an order stating that you are being evicted, and that would happen through one of three different types of court proceedings. The first being a non-payment proceeding, which is just as it sounds. That is when a landlord would be suing you in housing court for not paying your rent, allegedly not paying your rent for whatever period of time. A holdover is when your landlord believes that you are staying past the end of your lease. If you have not signed a renewal lease and your lease has ended, your time in the apartment has ended, but you're still living there, they would file a holdover or a nuisance, in which case they would be filing suit against you for causing a nuisance to the building and your neighbors. And so I want to be very clear that those are the only ways in which that you can be evicted. For the topic of harassment, all rent stabilized tenants are protected from harassment by law. And that is a determination that DHCR makes. I will note practically that it is in the real world, it's difficult to prove. The process for doing that is you must submit an application and you go through an entire administrative process, kind of like court, where you have a hearing, you and the landlord will both present their arguments with or without attorneys, if you and or them have, and there are penalties that DHCR can impose to basically deter landlords, obviously, from getting to this place in the first place. But for you to be able to prove this, as I've said earlier, you need quite a few records. You need a lot of evidence to be able to prove this. And that's the reason why I said to always make your records, keep your records, because you never know when you might need them. Next slide. So now lease renewals. So rent stabilized tenants all have the right to a 1 or 2 year lease renewal. And I'll quickly just jump to timeframes. Your landlord must give you written notice of that right at least 3 months before the end of your lease term, but it can't be more than 5 months before the end of your lease. If your spouse, if you're legally married, then they can be added to the lease. And of note, your landlord might refuse to renew your lease if they believe it's not your primary residence. And so the way that DHCR has interpreted that is that you don't live there for at least half the year. You might be living somewhere else, and if you can imagine why, it makes sense because these rent stabilized units are for us everyday New Yorkers to live and work here. But of course, if it's some people might be aware of the term pied à terre, as in it's just kind of like a vacation home or whatever else, then that's not serving everyday New Yorkers and this crisis of housing shortage that we're dealing with in the city. So after that renewal is issued, you as a tenant, you have 60 days to accept. And to do that, you would sign and return it to them. After you do that, the landlord must they must sign, first of all, of course, on their end, so that there are both your and their signatures on it, and they must return that within 30 days. If you're not accepting, you must also let your landlord know and then leave at the end of your term. Otherwise, as I mentioned earlier, they can bring an eviction proceeding against you, called a holdover. Next slide. So now we'll talk a little bit about Succession, and we're not talking about the hit HBO show. Instead, we are talking about how people can continue to live in a rent-stabilized unit after the current tenant has either deceased and or permanently moved away. And so the two categories, or not the categories, I'm sorry, to do so, you must be a family member. And I put that in quotation marks because there are a lot of different people who are family members. They can be spouses, children, they can be stepchildren, they can also be a grandfather, a grandmother, grandson, granddaughter, as well as in-laws. In addition to that, DHCR will also allow non-traditional family members, but in certain circumstances. And so this is where, as in a lot of things that law related, and as I said earlier, the devil is in the details. So now that question of whether you might be a non-traditional family member depend on a lot of different factors, including how emotionally and financially committed you were to each other, or interdependent, which means how much you depended on each other for the time that you lived there. And so there are different examples for how you can show that in terms of the financial. That can obviously be both of you have had your names on bank accounts, or perhaps you both pay for everyday expenses while you've both been living there. Again, as I've noted before, you will need evidence of all of this. And at DHCR as well as with the courts, you of course can testify. You can be put under oath and speak to your relationship with the other person, but it always helps to have written records that might show, as I mentioned, both of your names on those bank accounts, or perhaps photos of both of you, engaging in family activities like parties or different life celebrations. All of that evidence will be very helpful for you if you are the person who is seeking to succeed. Um, no pun intended. So the other criteria is that you live together with the tenant for a minimum of 2 years immediately prior to their death or permanent departure. If the person who is seeking to succeed to stay in the apartment is a senior citizen, then that requirement is just 1 year, so not 2 years. So let's say your grandfather wants to keep living in your apartment after your father has been living there. They live together for 1 year, you're able to prove that, and then your grandfather can succeed. And the last note at the very bottom, if the tenant um, who has, let's say in this case, permanently left and moved away, if that person keeps paying rent um, and signs leases to renew their lease, other family members can still seek succession. So that doesn't mean that they can't, it doesn't mean that a family member cannot, it doesn't mean that, whatever else, they can still do that. Next slide. So now we're just going to go very quickly into a few different topics that all tenants, but specifically for our presentation, rent stabilized tenants deal with. So a security deposit, as I'm sure most of you already know, is paid when you move into an apartment to basically serve as security for whatever happens. Of note, for rent stabilized tenants, it cannot be more than 1 month's rent. Um, Additionally, if and when, as I'm sure many of our participants live in buildings where buildings have changed hands while they've been living there, the prior owner must transfer all of their existing security deposits to the new owner, unless they specifically have an agreement otherwise. Additionally, that security deposit must be placed in an interest-bearing bank account by the landlord. And that's something that perhaps not a lot of you may know, but you as the tenant are entitled to that interest. And as you can imagine, that can add up over time, especially over decades, as many people do live in units for multiple decades. And so they can have that interest paid out to them on an annual basis. They can have it held in trust, or they can have it even applied to their rent. And I'll note very quickly that a security deposit cannot be recovered in one of those court non-payment cases that I mentioned. They cannot be recovered as rent, but landlords can use the security deposit as an argument in a holdover case, saying that like you've stayed over and here is the security deposit. Some other things, and now we're getting into some social services that many of you may already know, but if you are at least 62 years old, if you are the head of your household and on your lease, or if you have succeeded, if your household makes 50,000 or less, and if you spend more than 1/3 of your household income on rent, then your rent will be frozen to that amount, meaning that it cannot exceed 1/3 of your household income on rent. And so I know that was a little bit confusing. I will spell it out. So let's say you are the only person that lives in your apartment and you make exactly $50,000 a year. You are over 62 years old, you're on the lease, And if your rent is more than $1,389, then you can apply for what is called SCREE. SCREE stands for the Senior Citizen Rent Increase Exemption. And the way that that works is that it will be a property tax credit that is issued to your landlord for that amount. So it won't be necessarily paid out to you to pay to your landlord. You don't have to worry about any of that. Instead, it'll be given to your landlord as a property tax credit, and then it's their responsibility to take that, to give you that credit for that portion of your rent so that your rent is discounted by that amount. Obviously, that doesn't always happen as it should. It sounds very straightforward and easy, but things are not as they don't always work out the way they should. And if that's the case, then you can and should bring that up with your landlord. The Department of Finance is who manages this program. You must also renew your scree. The Department of Finance will send you a letter once you apply and are approved for it. And 60 days before it ends, they will send you notice of a renewal. DREE is the version of this exemption, but for those with disabilities. And so the criteria for that is that you are 18 years old or older. Again, you're on the lease. Again, same thing. You and or your household makes less than 50,000 a year, but you must also qualify for either federal supplemental security, federal social security disability, a VA disability pension or compensation, disability related Medicaid, and also, even USPS disability pension or disability compensation. So that's another way that you can get an exemption. Of note, if you fall under both categories, you are above 62 years old, but you are also disabled. You cannot have both of those. So you can only have one. And uh, SH, yeah, SCHE, I'll admit I don't remember what it stands for now, is the version of this for those who live, if you're listening, for those who live in condos or co-ops. So there's an option for you all as well. Regarding late fees, so you can only be charged late fees, perhaps for late rent paid, if it's specified in your initial lease. If it's not, then you cannot. And there's a maximum for the late fees you can be charged, which is $50 or 5% of your monthly rent, whatever is lower. Another and moving to air conditioner fees, your landlord cannot charge you for fees for having an air conditioner if you yourself pay for power. And for washer dryers, if your lease does not say that you cannot have one, and if you do have one and your landlord does basically there's a period of time in which if your landlord does not bring it up, then they cannot charge you fees for having that. So those are just some quick things, some miscellaneous. Next slide. So now I want to talk very quickly about who can help you with what question. As I've mentioned in this presentation, you've probably heard me talk about DHCR a few times, and that is because they are the government agency, they're a state agency that deals the most with rent stabilization and regulation. However, there are other agencies, especially at the city level, that help with a lot of different issues. And frequently the question is, who do you go for what service? And 311 can and does help quite a bit with this. So does Google, of course. But while we're here, I want to take a few minutes to just go over the different things that the agencies do, some of which multiple agencies do, just so that you can learn and hopefully retain a little bit about who to go for what problem. Next slide. So this is a quick chart that I've made of, as I mentioned, DHCR, as well as the other important city agencies to in the second to the rest of the columns that will help for your different issues. So I won't read all of this out loud. I know that you all will have or are reading it right now. Um, you might be able to see a few things that you recognize. So for example, for DHCR, there are there are different types of service complaints that you can issue that you can apply for to DHCR on behalf of the whole building or in just your apartment if you have an issue. You can also apply to DHCR if you believe you've been overcharged on rent, and they will be the agency to take in all the information from both you and your landlord and make a determination on that. So you'll see that there are some different colors for font in here, and the reason for that is as follows. So for example, the red font is because those are all categories for violations. For HPD, those are the A, B, and C violations that I mentioned. Those are under the Housing Maintenance Code. And by and large, HPD will issue the vast majority of violations for a building for it could be heat or hot water, it could be broken tiles, it could be peeling plaster, it could be a whole bunch of different things. And they also do issue violations for lead, paint, and mold is in that cell above. However, you'll also see, I'll stick to the red for now. For instance, for DOB, DOB is the agency that issues structural or facade violations in case there's something falling off the front of your building. DOH has jurisdiction with rats and pests. DP, the environmental protection, is actually the agency that oversees if there are noise issues due to construction or whatever else. So it can be a little bit confusing that there are all these different agencies for different things, but that is the first thing that you have to learn and to recognize is just who to go to ask to get the right help. Just very quickly, I'll talk about in green, you'll see under DHCR that there's a tenant protection unit, and under DOB, there's a tenant advocate office, which obviously sound very similar. And so they can be very confusing. The first one, the TPU, is a proactive law enforcement office at DHCR for rent-regulated tenants. So if your landlord's committing fraud or if they're harassing you, then they proactively, through the capacity that they have, will find that, investigate that, and try to hold the landlord responsible for that. On the other hand, the tenant advocate office at DOB is for those tenants who live in buildings with ongoing construction. So let's say you are living in a building and the first floor is a commercial space, and let's say that store just left, and the next store that wants to come in is renovating before they come in. And with that renovation, there's just a ton of construction and different noise, which is disturbing your quality of life. They would be the ones to reach out to help with that. So hopefully this chart it's helpful for helping you understand who carries different responsibilities. Next slide. So that concludes our presentation for today. As Jakari mentioned before, please enter, if you haven't already, your questions into the Q&A tab at the very bottom of your screen. Um, I might have mentioned this before, I don't remember if I did. If the questions are too specific to the point that they would be legal advice, then we will not be able to answer them. If that's the case, we invite you to come in or give us a call, and we'll do our best to help you out. But the questions that we're hoping to answer here will be general ones that should apply to people in multiple situations.
Okay, thank you, James. Thank you for that very detailed presentation. Um, we have gathered quite a few questions for tonight, so I'm going to start with the first question, which is oh my God, my mom and I are are in a rent stabilized apartment. She recently died. How soon should the landlord be informed?
Yeah, so that's a good question, and I'll be the first to admit here that this is a situation where the devil is in the details, and I do not recall off the top of my hand. I think it's very important for us lawyers, especially, to acknowledge when they don't know something so that they don't give wrong information. And I'll admit that I do not know exactly how long it is, but I'm happy to look into this and get back to that person.
Okay. Next question is, our lease last year had two prices for a 2-year lease. The first year was at 1% increase, and the second year has another percentage increase. The form seems authentic. How are landlords able to do this? The rent is going up faster. Is it better to sign a 1-year lease at a time? We have historically signed a 2-year lease.
Okay, so this is a little bit of a specific situation, but I'll do my best to answer generally. So the rate at which, and I'm glad that this was brought up because this was something that I didn't have a chance to get into. If your rent stabilized, your landlord can only raise your rent by a certain percentage that is set by the Rent Guidelines Board, and that is a separate government agency that sets those rates. As you can imagine, what those rates are a point of some contention in the political world and all that, but they make that determination on the maximum that a tenant can be charged or increased for that rent. And so I would advise that person to take a look at what of those. I don't, so they said the lease was for last year, but to take a look at the Rent Guidelines Board's percentage increases to see that they are in line with that. If it is more than that, then the landlord is not able to do that, and that would be illegal under that law. Whether it's better to sign a 1 or 2 year lease, that is something that I cannot determine. It depends on your circumstances, and yeah, I understand that the question is likely, will the rates continue to go up? Is it better to be locked in? But that's always sort of a case specific answer because, if you've never lived in that unit before and you don't know if it's somewhere where you'll be happy in the second year, then obviously you might want to do a 1 year before you do a two. But that's it depends.
Okay, thank you, James. The next question is, can we get a copy of this slideshow? James, are they able to get a copy of it?
Yes, I believe so. I'll actually defer to you, Jakari, on the procedure for that. But yes,
That was
I'm
your
happy.
slideshow. You made it. So I wanted
Oh, I see. Yes,
get
I
it.
do. Yes, I do consent for it to be shared with whoever may like it.
Okay, perfect. Next question. When DHCR counts rent stabilized units, does that number include the affordable housing units under 421A or J51 programs?
Okay, so what that question is referring to is two different types of tax exemptions that landlords and or developers can get. So 421A, as many of you may know it as the housing lottery. So those are the exemptions that owners get if they have housing lottery apartments in their building. So if those buildings have rent stabilized units, let me just read this question one more time to make sure that I understand it. The affordable housing units. So I do not believe, and don't quote me on this, but I do not believe that that is the case. So the affordable housing units that are under the lottery are a different category. They are not They are not rent stabilized under DHCR, but they are under a different category of oversight.
Okay. And to the attendee who asked the question regarding their grandmother's rent-controlled apartment, please give us a call tomorrow, 212-491-2541. I will give our contact information again at the end. Um, since some apartments don't, I'm sorry, next question is, since some apartments don't have thermostats, how can you tell what the appropriate temperature should be?
Sure. So, thermostats in apartments are frequently, they do two things, right? Or they are intended to do two things. One of which is tell you what the temperature is at that moment. And the second thing is that it allows you to set the temperature at what you want it to be. Or that's the function of them. Obviously, I'm laughing because a lot of us have thermostats that don't work on one or both of those ends. And so, how can you tell what the appropriate temperature should be? Then it would be, determining the temperature on your own. You can obviously do that with a thermometer or some other way. Um, and if it's, as you guys might remember in the presentation, I talked a little bit about how heat season during the daytime depends on whether it is below 55 degrees outside. That is something that yeah, that's something that you can just, sort of consult by consulting the weather for that. But as for your internal apartment, if you don't have a thermostat, then you should get a thermometer to be able to measure that. And both tell it, as I've mentioned, to your super and or your property manager so that they have the opportunity to address it, but also to call 311 so that a heat and or hot water complaint can be issued, and that the appropriate steps, which is frequently getting the landlord to comply through court, happen. And I just want to reinforce that everyone is entitled to this. And so, of course, people may be afraid of escalating things or perhaps, making their landlord or their super or whatever upset. But again, this is your right. I want to make very clear that you are entitled to heat. We all are during these seasons and the way that it is. And so I encourage you to speak up and advocate for yourself because you can't rely on anyone else to do that.
Okay. For the person that has their hand raised, we are not answering questions that are like on the mic. So can you please put your question in the Q&A box? Thank you. I received a lease renewal the same month the lease is supposed to start. Do I still have 60 days to be signed? I reached out to the landlord twice about it and no response yet.
Okay, so just to sort of break down this question, this person received the lease renewal the same month as supposed to start, and so they, as I mentioned, the envelope was sent to them on February 6th, and the renewal was supposed to start in February 2025, so meaning February 1st. So this is obviously a situation in which the landlord sent it out late because it obviously started after their prior lease had ended. Um, Again, just to state the obvious, but you have every right to stay in your apartment, and so that is on them. With regards to the question whether you have 60 days for it to be signed, I believe that is the case, but I do have to double check on that.
Okay. The next question is, I have a pending case of 4 years of a reoccurring leak with a counterclaim on record. Do I need an attorney to get settled to settle for breaching my habitability? This is set for trial for May.
So this is one of those specific questions where I can't provide legal advice to anyone that we are not representing. And the question of whether or not you need an attorney is unfortunately very fact specific, right? I do like to tell a lot of people that the housing court system is set up for individual people to proceed pro se, in that you can represent yourself. And as I've mentioned earlier, if you do have all of your records and state your case and all of that, you can of course yeah, you can, everyone can and should have the right to represent themselves. Um, as many people may know, the Right to Counsel program also allows people to get assigned an attorney through a legal services provider in housing court, for instance, Lisney or Legal Aid or whoever else. And so the question of whether you need an attorney to be able to settle, uh, you do not need an attorney to be able to settle, because ultimately the question of settling or not comes down to you, the person. But I will note that settling does rely on negotiation, and negotiation does rely on knowing how strong your case is, perhaps versus the other side's, the landlord's. And usually it is attorneys that have the best sense for that. And so to be able to get the best settlement for yourself, it is likely that an attorney would be able to help with that. But whether you can settle, just period, you can of course settle on your own. You do not need an attorney if you, for instance, are okay with certain settlement, and if they agree to it, you can do that on your own.
Okay, next question. Old owner sold building while I was under succession process and I haven't received it. Does the paperwork also transfer over to the new owners? The lease is still under the estate name, but I have been paying the rent under my name the entire time. So I think the question just is like they apply for succession, and does that paperwork get transferred over to the new owners or new landlords who take over the building?
Yeah, so this is a good question. As I've mentioned earlier in the presentation, this frequently happens, right? Landlords and owners will sell their building to another owner, and the question is, what happens to myself, as someone who's been living there or whatever else? So the general principle in law is that a new owner does step into the shoes of an old owner, and so this question is specifically about whether the succession paperwork also transfers over to the new owners. I think that's a question. So just to sort of explain it, the succession process involves DHCR. As you might imagine, DHCR would have to know who the new owner is for that to happen. And so I, I'm not totally sure about this. My gut feeling is that it does transfer over, but again, this is one of those devils in the detail situations, and so I'd have to look into this a little further.
Mhm. Okay. Next question. What counts as harassment? Do you have an example?
So there are lots of little examples about this. And these examples, as I've mentioned, these are things that DHCR has found. And when I say found, that means that they've gone through an entire process of collecting a record, having a hearing, taking witnesses and evidence and all of that. And so there are lots of different examples of them, um, but I sort of hesitate to. I know it would be very helpful if I said one or the other, but I'll admit that I don't remember a ton of them, and I don't want anyone to think that just because one instance of perhaps a super um yeah, just like going up to a tenant's apartment every single day, does that constitute harassment every single time? I'd like to think that the answer is yes, but DHCR, like a lot of judges, sometimes they do change their minds and they can change their situations. And so on this, I will say that you should do a little bit more research and or consult an attorney who can tell you what previous situations have counted, but I unfortunately don't have the time to go into that right now.
The next question is, with Trump being in office, is there a way the rent stabilization can be affected?
Yeah, so that's a great question, and I'm sure that that is something that a lot of people are concerned about these days, especially because so many social services are either at risk or about to be at risk or are in the news about perhaps being at risk, such as Social Security, Medicaid, whatever else. So what I will note is that rent stabilization is a state regime. And when I say state, that is the state government, the New York state government. I think in the last few years, it's safe to say that a lot of people have probably been learning a little bit more about the difference between state and federal governments in terms of the types of things that that the powers that they both have. For instance, just to mention a few things, abortion or enforcement of immigration policies, things like that. And with rent stabilization, I do not believe that that would be affected by anything that Trump can do in terms of the laws themselves. However, of course, there's a lot of funding that starts from the federal level and trickles all the way down to the local level, with a lot of things related to housing. For instance, HUD and Section 8 issues, as some people who have been following the news may be aware of. And so I know this might sound like sort of a cop out of an answer, but we can't be sure. In terms of the laws and the rights, our governor has made very clear that the federal government will not be able to affect any of those things. But in terms of the day-to-day practice, implementation, whether an agency might even have enough funding to enforce X or Y, that remains to be seen, unfortunately.
Okay. Um, Next question will be Spanish. So I will come read that question. Yes, I believe it's two of them. Okay. Give me one moment. Mhm. But while you're doing that, then you could read the next question.
Got it. So it sounds like by liquid, they might be referring to leaks that have either started in that apartment or are affecting that apartment, and they have not finished the work that they were supposed to do. Um, so what I would do, this would be a perfect example of a situation where I would say that you should call 311 and let them know about this. And the reason why is so that they can refer it to HPD to be able to take a look and see what the issue is and issue violations, which would hold the landlord accountable to finishing it. Because, of course, as a lot of people know, starting work and leaving it unfinished is sometimes worse than even starting it at all. So I'm very sorry that you're going through the situation and that your property manager has not responded to your emails. but this is one of those situations where if you've reached out a bunch of times and if you haven't heard anything, it's important that you also let the government know so that they can do their part to hold your landlord accountable.
Okay. Uh, Question. I lived in two different units in the same building. Can I ask for the rent history from my previous unit? Yes.
Yes, I believe that you can.
Okay. We have two questions about succession rights. The first one, under what circumstances can succession rights be denied to a son or daughter whose mother is a legal tenant? I mean, that's kind of vague, right? We need,
Yeah, it sounds like this is perhaps a person who wants some certainty, perhaps. I'll say that I'm not sure about this either. Yeah, with regards to case by case situations, it is possible to look into how DHCR has ruled in different cases, or the courts have ruled in different cases. Off the top of my head, I'm not sure what situations they might have said that a son does not get a tenant. So I'm sorry, that can't be more helpful there.
yeah, so that person who asked that question, please contact Palante so we could further assist you. Next question is succession rights automatically granted? Can a landlord deny can a landlord deny it basically? Can a landlord deny succession rights?
So a landlord cannot deny it legally. I'll put it that way. Of course, that does not stop a lot of them from trying to deny it, so that you cannot move in, and that and that a fight ensues, or they are hoping frequently that you do not fight it and basically give it up. Um, but as for how succession works. So the way that works is that you have to send a letter to your landlord explaining that the tenant of record has died, has permanently moved, or whatever else, and that you or the person, the family member, is entitled to become the new tenant. And so, yes, I mean, as I mentioned, a lot of times landlords may deny granting that. If that is the case, then DHCR would be the ones to step in. Also, the courts can do so as well.
Okay. Uh, if bedroom walls are showing cracks as if the building structure is shifting, what agency do I contact to assess the problem?
Yeah, so as I've mentioned, there are multiple agencies that cover different things. Um, and unfortunately, this also sort of does depend because sometimes multiple agencies do oversee both things. In this situation, so DOB, the Department of Buildings, definitely, as with regards to structural issues, would be the ones to consult. And you could bring it to their attention by going to 3011. And if there are issues with the apartment on such a serious structural level that people will be at risk of it collapsing, and I'm sure people have heard about these sorts of things in the news as comes up every so often. There was an issue of a parking garage, collapsing. Then DOB would even issue sometimes what's called a vacate order, which means that no one can reside or use that premises. So they would be the ones to consult for that.
How do we ask that the interest earned on our security deposit be applied to future rent?
Yeah, so that also um, I personally am not sure. The devil is in the details there. I do believe that you would have to make that request in writing to your landlord or to your property manager for that to be done. And you should explain, obviously, all the months and years for which you'd like that to be done. but you should make that request formally rather than just a phone call or whatever else. Make that in writing with the, as I mentioned, the months and the dates for them to do that, and they should apply it to your rent ledger so that you can see that take effect.
Next question is, um, oh, someone's asking again about the security deposit. Um, so we will send you the presentation for the person who asked that. They're requesting that. Um, how can a rent stabilized apartment that is falling apart get fixed slash renovated? When mentioning apartment needs to landlords, appliances, floors, ceiling, outlets, etc. to landlords, landlords inform tenants if the apartment gets renovated slash fixed, the tenants will have to pay market value for the apartment. Yeah.
Yeah, so that's a good question. And just to explain very generally, there are these principles at DHCI, or principle by principle, I mean there are different mechanisms by which landlords can request increases to rent for improvements to the building. So two of those are called MCIs and IAIs. An MCI stands for major capital improvement, and an IAI stands for an individual apartment improvement. And there's a whole process through which a landlord has to save all of their records for that to prove that those changes were done. There's a monetary amount limit to the amount I believe that they can do. Um, and I believe this question, so it's, and in addition to those two things, there is a principle called substantial rehabilitation. So what that refers to is when as it sounds, a building or unit, I believe it's building, is majorly renovated, and there are a bunch of different requirements for that. For instance, at least 75% of the building systems must be replaced. Of course, then you ask, what does that mean? What are systems? How do you define 75%? Um, it must have been in a substandard or seriously deteriorated condition. Again, you ask what, goes to that. And DHCR is the agency that would determine that and to make sure that's the case. Um, I do want to make clear that it is a pretty frequent situation that landlords, as you can imagine, if they're just charging rent, regulated rent, then they feel like they're not making as much money as they are market rate tenants. And so they want to obviously charge market rate because they can get more. But the the whole point of rent stabilization and the laws that exist is to preserve the rights for the people that live in these apartments to continue to live in them under affordable rents for long periods of time. And so there are caps between what I've mentioned, the MCIs, the IAIs before the substantial rehabilitation, in which case, tenants have to pay that market rent. And there's a lot of details, so I won't go into that. But there's a lot more to that, to those topics. And I encourage the person who asked that, if they're living in an apartment or a building where that is going on and they're concerned about whether it'll be changed to market rate, that they reach out to an attorney who can help with that.
Next question, can a landlord change the DHCR report to suit their agenda?
So I'm not entirely sure what that question means, but what I will say is that DHCR in this situation um, acts as sort of the record keeper here, right? So landlords are required to submit filings to them, and DHCR is the entity that keeps those records. And as I mentioned at the very beginning of the presentation, provides copies of rent histories, rent registrations, whatever else to tenants who request them. So whether an owner can change first of all, I think the question mentioned report. There's a lot of different reports, so I'm not sure exactly which one it's referring to. Whether they can change that to suit their agenda, that landlord themselves cannot change anything. They can perhaps give different information, which might be wrong, which would then be illegal, of course. So whether they can do that, it would depend on the information that they give. And obviously, without being specific, we all sort of know that the range of behavior for landlords is as far as their imagination, right? Whatever sort of you can think of that they can do, they probably have done. And so that's how I would best answer that.
All right, thank you, James. Next question says, if a new owner purchases your building and wants to buy you out to destabilize your apartment, do you have to take the offer or can you remain while the building undergoes new construction or becoming a condo?
Yeah, so there are some rules about this. So a new owner purchases your building and wants to buy you out. So buyouts are a topic that we here at Palante specifically, we do not deal with people who or clients who might be considering buyouts for the reason that I mentioned before, because we are seeking to retain, if not increase, the supply of housing for everyday New Yorkers here so that everyone can live here. And if you can imagine, or if you can understand a buyout, if it makes a rent stabilized unit turns into market rate, then the rent would only go up, which would make it difficult for all but a certain population. So the question is, do you have to take the buyout offer? The answer is no. You do not have to accept any sort of offer that you do not agree to. And can you remain? And that also it depends on several different things. As I mentioned before, vacate orders, when they're issued by DOB, HBD, or different agencies, those are basically a governmental order saying that you cannot live there. Frequently for fires, for example, that have, gutted the building or main part of it, or as was mentioned before, a lot of structural issues that the building might come down at any given point, and so people can't be living there. So can you remain? This again depends on lots of things. If, as I said, the government determines that no one or you should not be there, then you cannot be there. But then, if you're a rent stabilized tenant, you would have rights in terms of your landlord paying for part of your relocation, whatever else, but all of that is very fact specific.
Mhm. Can you give some examples of how buildings/units could become exempt from rent stabilization due to being substantially rehabilitated?
Yeah, this too, it's a little bit difficult. I mentioned a few questions ago, or my answer to a few questions ago about the different criteria, about the 75% of at least 75% of a building systems must be replaced. The building being in a substandard or seriously deteriorated condition. So it's a little bit hard to present an example, to sort of point at a building or to be like, hey, if a building replaces its boiler, does that count? I unfortunately can't answer that. But that's something that you can definitely look into further to see sort of as helps a lot of times in these situations what previously has been considered to be substantially rehabilitated and perhaps go from there.
All right. Next question is, there was a fire in our building. All five rent stabilized units were flooded, and now the owner has reconfigured the second to third, I don't know if that means floor, but will they still be rent stabilized? Do they have to notify DHCR, and DOB prior for permission for the conversion?
Yeah, so this is something that that landlords frequently do, or try to do, which is it's called, the term is called Frankensteining in the world, which is where they increase or they combine apartments in an attempt to increase rent. They would do that also for rent stabilized units to because doing that would make it not rent stabilized, but instead subject to a market rate rent. So in this situation that was mentioned, there was a fire, and then the units were flooded, and then this owner took advantage of this opportunity to reconfigure these apartments. That would not be legal. So the tenants would be entitled to all their units. As you can imagine, when units get combined, or perhaps sometimes units one might get enlarged, what happens is that another one has to get smaller. And again, the general rent stabilization regime is that you are entitled to your situation as it was before a fire. And if you come back to your apartment and there's less space in it, then that would not be permissible. As for what exact law, that would violate, I can't say that off the top of my head, but yes, that's how I would answer that.
Mhm. Next question is regarding rent histories. They're saying they're on the website but don't see the option to request. The slides you had, did it
Yeah,
have the information for DHCR?
it did. Jakari, if you want to go back to, I think slide 4 of the presentation with the QR code. Yeah.
This one?
Yes. Um,
So maybe it's best they call if they're having issues on the
Yes,
website.
correct. Exactly. So I just went to that URL myself while I'm on this presentation, and it pulls up for me. It seems to work fine on a computer. Maybe if you're on a cell phone, it might be harder, or perhaps you're on a different page. But if you are having issues, as I said, there are also, you can address them by email and phone, and they should get back to you. But I, again, do encourage everyone, if you're not already sure that you are rent stabilized, to take this time right now, tonight, and or later, to find out by taking one of these three, by reaching out by one of these three methods, because that's very important and will sort of affect all sorts of things down the road, as I mentioned, in terms of leases, how much you can be charged in rent, and all sorts of things that affect everybody. So I, again, highly encourage everyone to do this if you haven't already. And once you get those documents back, if you have questions, there are a number of organizations that can help with that. We can also help with that to help decipher what your results mean.
Hmm. Thank you, James. The next question is, can I ever own my rent stabilized apartment, especially if I've been a tenant over 43 years, renting to own?
Yeah, so that's a good question, and that's obviously a very understandable question, because some people may not want to rent forever, or some people may want to have equity in their place. I don't believe that that is possible. I'm trying to think for a second. Uh, Ultimately, whether you can own an apartment that you're living in, well, I'll explain this way: is that as I've mentioned, the whole system of rent stabilization is to preserve apartments for as many people as possible for as long as possible. If your building were to somehow be converted to a system of ownership like a condo or a co-op, then there, again, there's a lot of details in that process. There with I believe that there's a certain number of tenants in a building that would have to agree for that change to happen. and all of that. And so again, the devil is in the details, and including, I think, whether your landlord would be willing to adopt that change.
Absolutely.
Also, whether the law allows for that, which I believe is yes, but again, I'm not totally sure, unfortunately, for which I apologize.
Okay, next question is, can succession rights be claimed on a nuisance case?
Yeah, so the question here is, as I mentioned, nuisance cases are a form of housing court case, are a form of eviction proceeding where a landlord is suing a tenant, claiming that they are a nuisance. And I think the question is, can succession rights be claimed during that process? So perhaps saying, um, or perhaps having the court determine, while it determines the nuisance eviction, to also determine whether succession has happened or not. Um, I believe it's possible, but just in general, sort of the way that the court system works, and cases generally work, is that cases are brought for a specific reason, and for different arguments, and then defenses can be brought by the other side. In the case of the nuisance cases, by a defendant, but by a tenant, saying, arguing no. So for this example, no, I have not caused a nuisance, or no nuisance has been present here. So I guess the question, if I'm understanding it, is would succession somehow be a defense in a nuisance case? And that's not a question I've been asked before. I am not sure. I'm sure that there are very specific situations where a tenant might allege that, but I personally am not sure. I'm sure an attorney who has been practicing in this field for many years might know the answer, however.
Mhm. Next question is, if a new owner wants to turn your building into a condo, can you remain as a rent stabilized tenant?
Yeah, so I think we sort of covered that question a few questions ago. Whether it gets turned into a condo or co-op, very generally, you as a rent stabilized tenant have a right to live there, and they cannot, just because they want to turn your unit into market rate, they cannot do that without undergoing a lot of different processes, and you have a lot of rights in that process. And so if that's something your landlord is trying to do or trying to make you believe is the case, then we highly suggest that you get a lawyer to help you out for your specific situation. Chikari, I don't hear you through my headphones, or since we're in
Can
the
you hear me
same room,
now?
I hear you now. You might want to repeat that.
You can hear me though.
I can, correct.
So the question was, do I have the right to rent space in my garage?
I have a right to rent a space in my garage. So I assume what this person is saying is that they are a rent stabilized tenant. Um, I'm a little bit confused when they say my garage, because I will assume that you are a tenant of a unit that also has a right to a garage, and that you want to rent that space out to someone else. So if you are a renter, and if you're trying to rent out your apartment or your own space, the term for that is called subletting, which I'm sure a lot of people know. Um, with regards to this specific situation, I'm not sure. If I were you, I would take a good look at the lease that you've signed to see whether it allows you to do that. That is frequently the case for a lot of different um, building, or a lot of different situations, including market rate situations.
Okay, we have time for two more questions and then we're gonna wrap it up. Um, the next question is, I'm the successor of my father's unit who has passed away. We both signed the lease previously, but he was the primary tenant. Before his passing, I started paying the rent. Can management deny to renew the lease if they increase the rent to market rate?
Okay, so I'm just taking a second to read this over. Yeah, so this is one of those specific situations. I would recommend that the person who submitted this question call in, and we might be able to assist with that. But yeah,
Okay. Oh, they filed about the garage. She says I have a parking garage in my building that I would like to rent. I live in a co-op.
yeah. So if you live in a co-op, then you do not live in a rent stabilized unit. So that would be outside of the scope of this presentation. But if you want to rent a parking garage in your building, whether you are a shareholder of a co-op or a renter within a co-op, either way, you would have to go through your property manager. They're the ones that determine who and when parking spaces can be rented for whatever rates. A lot of buildings have waiting lists for them, as there are frequently more people who want to rent parking spaces than there are spaces, and so they'll be the first person to ask about that.
Okay, so I think we're gonna wrap up the Q&A for tonight. I want to thank our attorney James for presenting tonight and answering all of your questions or the ones that we could get to tonight. If your question was not answered or if you would like further follow up with Palante, we can be reached at 212-491-2541. We're open Monday through Friday, 10:30 to 7 p.m. I also want to thank all of our attendees for joining and participating. I hope this webinar was helpful and that you have some valuable takeaways from James's presentation and from him answering your questions.